The National Anti-Corruption Commission. Let's get this right. No matter which side of politics you stand on, we all agree that corruption is bad and there is no place for corruption in Australia. It threatens fair and effective governance and should be properly investigated and punished. We also agree that human rights matter, that human rights protect us, that too much power granted to one body may be abused, and finally, that accountability matters. So let's look at the National Anti-Corruption Commission through the lens of these important human rights principles. Firstly, our human rights are a protection that allows us to live, work and enjoy our families without having to worry about arbitrary attacks on those things we value. Important human rights include that every person, no matter the accusation, has the right to equal protection from the law and the presumption of innocence, a fair and prompt trial, protection from retrospective laws, and also protection against an attack on someone's reputation. Unfortunately, in New South Wales, some of these human rights have been trampled on by New South Wales ICAC. In a recent report by the Rule of Law Education Centre, it found that 71% of individuals found corrupt by New South Wales ICAC were not found guilty of criminal conduct by New South Wales courts. This has resulted in reputational damage, and for those labelled as corrupt, they have no way to review the merits or remove the stain of a corrupt finding. Furthermore, the report showed that on average, 4 years pass between the complaint, tip-off or report made to New South Wales ICAC and the individual's court's finalisation. During this time of delayed justice, their career is often on hold, their bank account frozen, and they are put under considerable stress. As we said, every Australian citizen holds the presumption of innocence, or the right to be presumed innocent until proven guilty beyond reasonable doubt. But New South Wales ICAC has repeatedly damaged the public reputation of people who have not been proven guilty or corrupt by the New South Wales courts. This is a breach of basic human rights. Furthermore, under the new proposals for the National Anti-Corruption Commission, it can act retrospectively. This means it can make declarations of corruption findings against people who have previously acted in a way that is currently unlawful but wasn't at the time of their conduct. This is a breach of basic human rights. We also all agree that too much power granted to one body may be abused. As a result, the investigator, judge, jury, and executioner should not be the same body. Like police investigations, the National Anti-Corruption Commission investigations should be held in private to avoid reputational harm. Coercive powers should not be used. And importantly, when the investigation finds sufficient material of serious criminal conduct, it should be referred to the DPP or Federal Police. This raises the question, what exactly do we want the National Anti-Corruption Commission to do? Is it a court? If so, it must follow the rules of evidence, have the right to an appeal, and stop show trials. Or is it an investigator? Then why is it holding public hearings? Like the Coroner's Court, the National Anti-Corruption Commission should suspend an inquiry once it is clear that an indictable offence may have been committed, and refer the matter to the AFP or the DPP. Finally, we all agree accountability matters. The National Anti-Corruption Commission and its findings should have a review mechanism. Somebody must watch over the watchdog. Like the courts and government organisations, there must be the ability to review the findings of the National Anti-Corruption Commission on issues of law and issues of fact. And, like the courts and other government organisations, the National Anti-Corruption Commission must be held accountable via benchmarks such as time standards and costs per matter finalised. One only has to look at New South Wales ICAC's annual report from 2020 to 2021 to raise the question, is New South Wales ICAC model worth replicating? This graphic is taken from their annual report. See that little triangle at the top? It shows that only 1% of matters proceeded to investigation stage. This report also revealed that last year New South Wales ICAC had expenses of $28.6 million and only 7 people were subject to a corrupt finding. That equates to a cost of $4 million per person found corrupt. Another table from the ICAC's annual reports shows its own failures to meet time standards. As you can see, ICAC met its time standard of 16 months, a mere 20% of the time. This is not saying that the staff at New South Wales ICAC are not working hard, but maybe their scope and role is too wide. That raises the question, is New South Wales ICAC model worth replicating? So let's do the National Anti-Corruption Commission right. We need a clear definition of corruption, limited to serious matters only, for those in public office. We must insist that the National Anti-Corruption Commission follows rules of evidence and its powers are limited to investigation. As an investigative body, it should only hold private hearings. And if it must make findings, there must be an ability to appeal those findings. For more information, go to our website www.ruleoflaw.org.au.